Miss Lane.
May it please my lords, in this matter I appear for Apple with Mr. Jeremy Heald, and my learned friend Mr. Thomas Hinchliffe and Ms. Jennifer Dixon appear for Optis. My lords will have appreciated that this appeal is about an invention which amounts to a pattern, and I like to think of that pattern as a checkerboard tablecloth with red and white squares, and then somewhere in it you've got a blue stripe with a white stripe on one or both sides. And that is what appears in the visual aid, which is on the back page of our skeleton argument. And by way of introduction, although obviously I'll be coming back to this in much more detail, each one of these coloured blocks on our visual aid represents a separate mobile phone signal. And you can only see the pattern, and it's only meaningful when you have all the mobile phone signals together, controlled by the base station. And in that situation, you achieve the object of the invention, which is to make sure that interference is minimised between these different coloured squares representing mobile phone signals. Now, the fly in the ointment for Optis is that it is common ground that this pattern is never signalled in the United Kingdom. Therefore, the object and the benefit of this invention is never achieved or taken advantage of in the United Kingdom. And we say that the problem with the judge's approach to construction and to infringement, which obviously we say he was wrong on both of those, is that protection is given not to the pattern as a whole, which is what the invention is about, but to the mere possibility that one mobile phone could participate in making this pattern. And so, if you like, by way of analogy, there are spools of thread waiting by the loom, which could be used, but they haven't been loaded onto the loom, let alone woven into this pattern. And we say this approach is wrong because it's not warranted by the wording of the pattern, the patent, and it's not warranted by the case law on adapted to. And by way of fallback position, we say it leads to invalidity, at least of one of the two patents, because the construction adopted by the judge would lead to Nokia, which is a particular piece of prior art anticipating the patent. Now, just to explain how I propose to approach the order of my submissions, I'm going to divide it into two parts. So part one relates to both of the patents, and it's not necessary to distinguish between them for these purposes. And so I'm going to address in the usual fashion the technical background, the patent. Then I'm going to look at construction of the claims, the adapted 2-point, and the novelty squeeze. And then in part two, I'm going to deal with the single patent, the 810 patent, and I'm going to look in that context at the COBE agreement, the construction point in relation to the 810 patent, and then in relation to the third point, obviousness. Now, just a preliminary point before I launch into part one. Optis asserts in its skeleton that we are merely asking this court to carry out a balancing or evaluative task afresh. We say that is not right. The points that we raise in our skeleton are all points of law, so they are points about construction of the claims in relation to the point about whether the code multiplexing structure has to be in use, or they are points which are about construction of Nokia, and that is related to construction of the claims. So again, not approaching an evaluative task afresh. Then we've got the adapted 2-point, which is all about looking at the Court of Appeal decision in IP, Vodafone. That's a pure point of law. And in addition, in relation to the 810 patent, again, we're looking at construction of the COBE agreement and the patent. And we do have an obviousness point in relation to the 810 patent, but that depends entirely on construction. So we say that these are all points of law, and so the higher threshold isn't required to be met for any of these, although we would say in any event that we can show a gap in logic, a lack of consistency, or a failure to take account of some material factor. So turning to part one and the technical background, and what I'm going to attempt to do is to walk my lords through just a few key bits of the background, because in fact we say that the judge was right to say that the technical background need not be all that complicated. And in particular, now that we have reached the appeal stage, we only really need to understand limited bits of the judgment. And in my submission, it's helpful to go through that because the difficulty with the judgment is that it was basically based on the agreed statement of CGK, and that covered a very large number of issues, and it's been filleted down somewhat, but we need to look at fewer issues now. So turning up the judgment, which as my lords will be aware is in tab 5 of the core bundle, and starting with a couple of very basic points, absolutely, if I'm going too slowly at any point, please let me know, but I'd rather go more slowly and be told to speed up than the other way round. So the first basic point is at paragraph 12, which is at core 71, which is that, as my Lord Justice Merson, Lord Justice Arnold will be aware, there's this jargon, which is that a mobile phone may be referred to as a UE, and you have the base station, which can also be referred to in other ways. Now, what we're concerned with in this case is a particular generation of mobile phone technology called LTE, long-term evolution, and that is referred to by the judge at paragraph 54, which is in the core bundle at page 79. So there are other generations, but we're concerned with LTE. And if we go over to the bottom of that page, paragraph 57, there's this 7-layer model, but we are just concerned with the physical layer. And moving over the page, in particular in the physical layer, as explained at paragraph 58, we are concerned with something called the PUTCH, which is the physical uplink control channel, and that's a physical layer channel which is used to carry certain types of information between layer 2 on the mobile device and layer 2 on the base station. So the next thing that we need to understand is multiple access methods on the PUTCH. And as the judgment goes on to explain further down that page, core 80, the radio spectrum that is, this is paragraph 61, the radio spectrum that is suitable for use within a cellular network is a finite resource. And in particular, as explained at paragraph 63, different transmitters within a cell, the base station, the mobiles, must all access this finite resource in an efficient manner. And so, in order to access the finite resource in an efficient manner, you've got to share it out. And the two ways of sharing it out that it's necessary to understand for the purposes of the appeal are the LTE frame structure and codes. So the LTE frame structure is explained at core 88, which is paragraph 116 onwards of the judgment. And what is explained there is that LTE uses a resource grid, which describes both the uplink and downlink frame structure. And the smallest part of the resource grid, I'm looking at paragraph 117 now, is the resource element. And this is describing here, or starting to describe, figure 10, which is on the right-hand page. And it explains at paragraph 118 that resource elements are organised into resource blocks. And a resource block contains 12 subcarriers, and each of these subcarriers is 15 kilohertz, so they add up to 180 kilohertz in frequency, and the duration in time of an RB is 0.5 milliseconds, which is also sometimes described as a slot. And what...
Can you just remind me, I should remember this because it's not long ago since I last did one of these, but I constantly forget what are symbols in this context?
As I understand it, that's another further subdivision, effectively, of a subcarrier. So there are 7 symbols in a resource element, if I remember rightly. My junior's going to tell me if I'm wrong at this point.
The judge says either 6
or 7.
Oh, yes, 6
or 7, yes.
Yeah. Okay.
And then at paragraph 120, it explains that the resource grid structure allows the frequency and time domain positions of various channels and signals to be easily described when the base station sends uplink and downlink resource allocations, and when large amounts of data are to be sent, multiple RBs can be assigned. So you've got that frame structure. In addition to the frame structure, you've also got codes. Now, codes are introduced...
Sorry, Miss Lane, I thought there was 1 symbol in a resource element, a 7 in a resource block.
Oh, yes, sorry, I misspoke. I should have said, yeah, you're...
Fine.
1 in a resource element and 7 in a resource block. I'm grateful for that clarification. So then we come to codes, and codes are introduced at paragraph 71, and in fact this section introducing codes is talking about the pre-LTE position, and so it only introduces one particular type of codes, but it's a type that we need to understand. And what is explained at paragraph 71 on core 81 is that CDMA does not use separate times or frequencies. So what we were looking at with the resource block was times and frequencies, but instead uses a process known as scrambling. Each mobile is allocated a unique scrambling code, which is used to scramble its data before transmission. The base station can recover the information transmitted by each mobile device by performing descrambling using the same scrambling code used by the mobile device. So one way of thinking about this is effectively each mobile is allocated a different language. So I'm going to send mine in French, and then when it's received in French, that we know that is one particular code. And except in this case, of course, the codes are mathematical functions. And one type of code that we need to understand is explained over the page under the heading orthogonal code and codes at 79. And it says that orthogonal codes were used in 3G CDMA systems, including UMTS. They're made up of a series of binary bits represented by 1 and -1 and arranged in a particular order. Now, in fact, it's not really necessary to understand the bit of maths that's at paragraphs 80 and 81, but it is necessary to understand what follows at 82, which talks about the spreading factor of the orthogonal code. And this may be thought of as the number of bits used to construct the code that encodes a single bit of data. And for example, in paragraph 80, that has a spreading factor of 4. And then it explains that spreading is the process by which a user's data bits are multiplied with the bits that make up the code. This can have the effect of spreading the data out over a longer period of time. And then it goes on to say at paragraph 84 that data from different users is spread with different codes, and then the outputs are received by the receiver as a composite waveform made up of the signals from all the different users. The receiver knows the code used by each user and applies this code to the waveform that it receives in order to pull out or despread the data for a particular user. So it translates it effectively. And then again, there's a reference to the spreading factor in paragraph 85, and we'll see that the spreading factor is something that features in the patent.
Yeah, can you just help me on that? The judge says it's n-1, but then he says for spreading factor 4, there's 4 available orthogonal codes. Why isn't it 3?
Oh, okay. So it's a code with 3 codes orthogonal to it, which means there are 4 in total.
Right, I see. Thank you.
And then another important thing just to register at paragraph 86 is that these codes are sometimes called Walsh and Hadamard codes. So, I mean, it's yet another occasion on which, just to confuse everyone, we use lots of different jargon. Blockwise spreading code, Walsh code, Hadamard code, you can assume they're basically the same thing for the purpose of this case. Now, as I've said, there is another code that we need to consider, but it's not introduced at this part of the judgment, so I'm going to come back to it in a minute. But what I am going to do is go on down page 83 to the heading Impairments in Mobile Systems, because this is another important part of the background. And so, as it states, or as the judge states at paragraph 87, there are various impairments in a mobile communication system which can degrade the signal that's received, and if the impairments become severe enough, it can be impossible for the receiver to recover the original data. And then the judgment goes on to explain various different impairments. So we've got noise, which is an unwanted signal superimposed onto the original transmission. We've got interference, which is an unwanted signal from other devices. We've got frequency offsets, and that means that you might have an error in the transmitter or receiver frequency, which can degrade the ability of the receiver to recover the signal. And it explains that that can be caused by, for example, Doppler offset, which is explained below. And then you've got the heading Channel Conditions. And if I could just ask my lords to read, I know you'll have read this already, but to read again paragraphs 91 to 94, because these are particularly relevant to the invention.
We'll do that.
Thank you.
Yes.
So essentially, you've got two types of spread: dispersion or delay spread and Doppler spread. And my lords will have seen how those are caused. And because of, and I'm going to come back to those, or we'll come back to those in the context of the patent. But because you've got these impairments in mobile phone systems, and it's not a perfect system, you've got to have some techniques for overcoming them. And that is what is introduced in the next section of the judgment. And in particular, we need to understand 2 techniques, because these are what the patent is all about. One of them is ACNAX, and it's here under the heading Automatic Repeat Request, which is towards the bottom of Core 85. And so what that explains is that if messages are detected with errors, or are not received at all, then they may need to be sent again. And this is often done using a process called Automatic Repeat Request, ARC, and that requires the transmission of control information in the opposite direction to the information being sent. These are acknowledgements ACKs or negative acknowledgements NACs, which indicate that the message has either been received correctly or not. And then there's an explanation of figure 8, which actually is fairly self-explanatory in itself. So message 1 is sent, there's a green tick, it's received correctly, and so an acknowledgement is sent back, a positive acknowledgement, whereas message 2 is not received correctly, and so a NAC, or a negative acknowledgement, is sent back. And this is introduced here under the heading or in the context of arc, in fact, in this pattern we're talking about hark, but we don't need to understand the difference between them. Ax and nax is what we need to know. So it's a type of signal that tells basically the base station whether or not the message has been received. So that's one type of signal we need to understand. The second type of signal to be understood is the CQI, which is addressed in the core bundle, page 87, paragraph 112 and 13. And the CQI is sent from the mobile to the base station and represents an estimate of the maximum data rate that the mobile can receive, and it explains what it's based on. But basically, it is telling the base station what the maximum data rate is, and so it's another important piece of signalling to make sure that everything is arriving where it should and is decipherable. And these are two types of control signals, and it's what the patent is concerned with. Now we get on to the LTE standard, and that really starts at, well, there's a heading just above paragraph 134 on core 91. But then we need to turn over to paragraph 138, and quite frankly, these standards are frequently not very comprehensible. So just trying to break it down into the bits that matter. You have got there a section 6.4 which relates to the putsch. We know this case is about the putsch, and that the putsch carries uplink control information. And then what it says is that there are various formats supported by the putsch, and those are listed in the left-hand column of the table, formats 0, 1, 2 and 3. Now, it would be quite good to know what formats 0, 1, 2 and 3 are, and that is explained in paragraph 156. And so what paragraph, that's on the bottom of page 94, formats 1 and 2 are for ACNAC, and format 3 is for CQI. So we need to know that in order to understand now paragraph 143, which talks about formats 0, 1 and 2. But what we're concerned with is it's talking about 1 and 2, and we know that they're formats for ACNACs. And what it is telling us then at paragraph 143, and it really starts halfway down that paragraph, section 6.4.2.1, that the formats are multiplied with a cyclically, these formats are multiplied with a cyclically shifted length 12 Kazakh sequence, and then blockwise spread with an orthogonal sequence. So what this is telling you is that two types of codes are going to be used in relation to ACNAC signals. One of them we've already looked at, that's the orthogonal sequence blockwise code, which was back in the section that introduced CDMA. And just so that my lords can understand why the judgment is written in this way, it's effectively in chronological order. So it introduces orthogonal codes earlier on because they were used in an earlier generation, and it's now moving up to LTE. But of course, we just really need to understand LTE. And so what it's adding is that for ACNACs, you're going to first of all spread them with something called a cyclically shifted length 12 Kazakh sequence. And then you're going to spread them with an orthogonal sequence. And we've looked at the orthogonal sequence, and now the judgment is explaining about the Kazakh sequence at paragraphs 144 to 146. And it explains that it's a sequence which has constant amplitude, and that it's also known as a Zadov-Chu sequence or a ZC sequence. and they are going to be used in the frequency domain. I'm looking at paragraph 145 now, on the putsch, and they're going to be of length 12 to correspond to the 12 subcarriers available in an LTE resource block. So that was what we looked at earlier, the LTE frame structure, each of which would carry one of the complex numbers in the sequence, and the length 12 different cyclically shifted Kazakh sequences could be formed from a length 12 root sequence. And then it goes on to explain that the properties of the sequence are such that 12 mutually orthogonal sequences can be produced by applying 12 different cyclic shift values to the sequence. When the base station receives a signal modulating the cyclically shifted length 12 Kazakh sequence from a mobile, it performs a correlation process, and from the peaks in the correlation result, it's possible to determine which cyclic shift was transmitted. And so essentially, that's just sort of explaining that the base station can understand which of the different cyclic shift sequences has been applied to which signal. So that is ACNACs. They're going to be spread with this Kazakh sequence and the orthogonal sequence. And then we get to CQIs at paragraph 153, and they are just spread with a cyclically shifted length 12 Kazakh sequence. So they are only spread with the Kazakh sequence. Now, I felt like I was romping through that, but we're just going to turn up the visual aid for a moment. Now, this visual aid obviously is not CGK, so I'm not purporting to say this is CGK, but I'm hoping that we can now understand the contents of this visual aid a bit better.
Meaning what you've got attached to your skeleton.
Exactly.
Yes.
My blue and white red and white tablecloth with the blue stripe. And what is shown on here, and as we've said, this is based on figures in the patent. You can now see on the tablecloth, we've got two types of signals, the ACNAC signal and the CQI signal. So the ACNAC signals are red and the CQI signal is blue. The ACNAC signal is being spread with the length 12 Kazakh sequence across the 12 subcarriers of the resource block. But it is also being spread with the Walsh sequence, which goes down the side. And in this case, it's just spread there into three separate rows. And that's why you get the checkerboard effect. In contrast, the CQI has only been spread with the Zadov-Chu sequence, which is why it fills the whole of one column, and it's not spread with the Walsh sequence. And the white gaps are empty resources. So I'm going to come back to this, and it is explained in more detail in the patent, but that just, I hope, summarises the key bits of the CGK, which are critical to understanding the patent, which is what I propose to move on to next, unless my lords have any questions about what we've done so far in the technical background.
I don't detect any.
So, turning to the claims, and I have been taking the claims from paragraph 203 of the patent, of the judgment. They are in the supplemental bundle, but it's easiest perhaps to take them from the judgment. It probably doesn't make much odds if my lords have marked them up in the supplemental bundle, but I'm going to actually take out pages 104 and 105 of the judgment, which is where the claims appear, because it's quite helpful to look at the claims and also at the judge's high-level summary of the claims at the same time. So the judge's high-level summary starts at page 108 of the judgment, and at paragraph 206. And he starts off at paragraphs 206 to 207, essentially explaining here, although he doesn't say this, but he's basically explaining integer 1a. And so integer 1a is the radio communication apparatus of a mobile station, in other words, a mobile, adapted to spread and transmit an ACNAC signal or a CQI signal in accordance with a code multiplexing structure for code multiplexing ACNAC signals and CQI signals from a plurality of mobile stations. So, as the judge explains, the mobile has to be able to spread ACNAC and CQI signals, but it isn't doing both at once. It's going to be doing one or the other. And the mobiles spread and transmit the ACNAC and CQI signals in accordance with a code multiplexing structure, which obviously, as my lords will appreciate, is a key part of this patent claim, although interestingly, and as an aside, it never appears in the description or the unamended claims. The judge says that he'll return to this concept in more detail below, but for present purposes he refers to figure 10. And figure 10 is a code multiplexing structure. And it's explained what is in that code multiplexing structure is effectively explained at integers 1b to d, which the judge addresses at paragraphs 209 to 211. And so what happens is the ACNAC signal is spread with a Zadov-Chu cyclic shift, and there are 12 options for that, and it's also spread with a Walsh sequence, and there are 3 options for that. And the CQI signal is only spread, as we've already discussed, with the Zadov-Chu sequence, and that is essentially explained if you look at the code, if you look at the claim in integers 1b to d. So 1b deals with the ACNAC signal being spread with the Zadov-Chu sequence, and then you've got at 1c you've got the CQI signal also being spread with the Zadov-Chu sequence, and then at 1d the ACNAC signal, after it's been spread with the Zadov-Chu sequence, is also being spread with an orthogonal sequence. Now, a peculiarity of the claim is that you've then also got integers 1e to h, which we don't need to worry about for the moment. In fact, as the judge goes on to explain, the claim is rather cumbersome. It's pretty repetitive, certainly in particular in integers 1b to h. But we don't need to worry about that, and in my submission nothing really turns on it in this appeal. But the next thing that the judge calls out in the claims is at paragraph 212, which is the 2 cyclic shift interval, and that is the checkerboard pattern. So that's the red and white squares, and it means that, as he explains, the fact that the square denoted CCE1 with Walsh sequence 0 is 2 cyclic shifts from the next time that Walsh sequence is used, which is at CCE2. And in the claim, that is explained at integer 1L. So it talks about a 2 cyclic shift interval mesh structure, according to which ACNAC signals for which the second orthogonal sequence number is set have a 2 cyclic shift interval cyclic shift values set that are offset by 1 cyclic shift value. I mean, it's a mouthful, but I don't think there's any dispute that it results in this checkerboard pattern. Then at paragraph 213, the judge goes on to explain that where a CQI is multiplexed, it will occupy the whole of a vertical column because it's not spread with a Walsh code. And furthermore, it's required that the cyclic shift following a CQI is not used, it is empty. And so that is to be found in integers 1m and n of the claim. So 1m says the CQI signals in the code multiplexing structure are not spread with any of the orthogonal sequences, and 1n says that the unused cyclic shift value is positioned after an immediately preceding cyclic shift value for spreading CQI signals. And as the judge explains...
Can you just help me on that? 1n starts with the words the unused cyclic shift value. Where's the antecedent for that?
Yes, sorry, I should have said that. It's at 1k.
Yeah, okay, thank you.
And what the judge explains, the reason for this is that it's intended to prevent the CQI from interfering with a following ACK-NAC in the event of delay shift. So remember delay shift we looked at earlier. So effectively the signal is spread out, the CQI signal is spread out, and so the concern is that if you occupy the cyclic shift immediately following the CQI signal with an ACK-NAC signal, then the two will effectively sort of merge into each other and will not be distinguishable. So the allegedly clever idea in the patent is that we'll leave a gap.
Ms. Lane, can I just make sure I'm not misunderstood, because I was going to ask the same question that my lord just asked about the antecedent to 1n. Just to be clear, as I read it, 1n does not, when it says the unused cyclic shift value, that feature does not apply to every unused cyclic shift value, which 1k does apply to. 1k is talking about the gaps between, say, for example, two ACK-NAC signals, but 1n is talking about the gap between a CQI.
Yes, I mean, it's certainly true that 1k refers to ACK-NAC and CQI.
Yeah. I mean, at the moment, the way I read 1n, it would make more sense if it said an unused cyclic shift value is positioned.
I mean, my lord might be right. I mean, I'm not sure that anything turns on it.
Okay, well, let's not waste time on it.
I mean, the judge refers to this point at 215, does he not? Particularly in the last sentence.
Right.
Yes, I mean, he's certainly referring to, well, he refers there to 1k, 1n and 1o. So he's linking 1k and 1n. So, moving on to paragraph 214, the judge says that figures such as figure 10 can be confusing at first, and one of the reasons for that is because, as my lords will appreciate, in the figures of the patent, unlike the figure that we've got at the annex to our skeleton, the CCE is shown as though it has not only been spread by using a Kazakh sequence, but also it appears to, in this figure, have been spread using a Walsh sequence, and that's because it's just shown in the middle block of the Walsh sequence, whereas in fact it should occupy the whole of that column, and that is what is shown in the visual aid. The blue CQI on the visual aid is a whole stripe rather than a single square, and a similar point is demonstrated at paragraph 214 of the judgment, although it's a little bit confusing because 214, the particular grid there is rotated round the other way. So it's got the Zadov-Chu sequence down the side and the blockwise spreading across the top, as opposed to the patent which has it the other way round.
And just being obtuse, why do we not have a gap in your embodiment 1 or figure 10 before the CQI?
So there are two different claims of the patent, or two different embodiments that we're concerned with. One of them only has a gap afterwards, and the other one has both a gap before and a gap afterwards. So in claim 1, there's only a gap afterwards,
Yes.
and in claim, I forget the number now, there is a gap before as well. Someone will... Oh yes, it's at paragraph 218 of the judgment. Claim 8 requires an unused cyclic shift before a CQI as well as after. And then at paragraph 215, the judge goes on at this point to describe the fact that the claim is cumbersome and that it's got these 3 spreading units, which are integers 1b, c and d, which we've looked at, and 3 control units, 1e, f and g, which we haven't looked at, but they don't really add anything. And then we've obviously got the characterising portion, and it's important to note that the characterising portion, that's the bit where you expect to find the invention, is starting at 1i, and in that characterising portion you've obviously got 1i and j talking about using certain cyclic shifts. You've got 1k talking about not using certain cyclic shifts. Then you've got the 2 cyclic shift interval that we've already looked at L, and then we've got more discussion of the unused cyclic shifts. Well, first of all, we've got the fact that the CQI signal isn't spread with the orthogonal sequence, and then we've got the unused cyclic shift at 1n. And then paragraphs 217 and 218 just explain some other features of different claims, because obviously we've been talking about claim 1 up until now. And in particular, the point at paragraph 218, which we were just discussing, which is that claim 8 requires an unused cyclic shift before a CQI as well as after. So on my visual aid, that is the bottom embodiment, which relates to figure 13 of the patent.
Elaine, I thought I'd figured this out, but I've now forgotten again. In figure 48 in the patent that you were just showing us, just above 215.
Figure what, sorry, my lord?
It's figure 48. It's the figure just above paragraph 215 of the patent. Sorry, of the judgment.
Yeah, yeah.
I think I did remember, but I can't remember now. Why is the 3 blue? Why is there a blue one?
Oh, okay. My
Does it matter?
My learned junior has just reminded me that figure is taken from Nokia, which is a piece of prior art. And in Nokia, well, it's based on Nokia, and in Nokia it's marked blue.
Nice. Fine. All right, well, let's not worry about it.
Sorry, it's Nokia 002.
It's Nokia.
No, it's Nokia, apparently.
All right. But it's come from Nokia.
Yes.
Well, what the judge says is that it's what Mr. Edwards said the skilled person would get to from Nokia,
Yes.
to be precise.
Yes, my lord, you're absolutely right. That is what it says. So, but that's why it's marked blue. It's as I understand it, it's nothing of significance in relation to the patent. And in fact, part of the reason for putting this in is because this does relate to the patent figures, whereas this, whilst it's obviously is related, it's the other way round, so it just confuses things a bit. So that is the sort of introduction to the claims, and don't worry, we will be coming back to more on the claims when we get to my submissions.
But sorry to interrupt you, I don't think this matters at all, but as far as I can work out, this wasn't an idiosyncrasy of Mr. Edwards, because if you look at core bundle page 118, examples of MRB configurations are given, which are taken, the judge tells us, from the agreed statement of technical issues relevant to essentiality.
Yes.
And those all have the same format.
Oh yes, absolutely.
With the orthogonal code across the horizontal and the cyclic shifts down the vertical.
Absolutely. I wasn't trying to suggest, apologies if I did, that there was something wrong with displaying it in this particular format. It's just, it's not the same as the patent. And so if you're trying to understand the patent, it's the other orientation.
Yeah.
The fact that it's in blue may be perhaps not an idiosyncrasy, but just and it's not. It's a feature of where it's been taken from. The fact that it's in blue. I actually forgot to do one thing which I intended to do at the beginning of this section. I'm sure it won't be the last thing I forget today, which was to get at core 103, where the judge introduces the claims of the patent, to just take my lords to that, because at paragraph 198 he lists out the claims in issue, and he points out at paragraph 199 that they're all product claims, and that Optis gave up on the method claims because the functionality in the standard is not used in the UK, and so Apple neither offers the method for use by purchasers of its phones, nor provides means essential for putting the method into effect in the UK. So there was originally a pleading of infringement of the method claims, and that fell by the wayside and wasn't pursued. So now we can move on to the description of the patent, and for that purpose we need to go to the patent itself, and that's in the supplemental bundle, and I'm going to take all the references from the 549 patent, which is at tab 1. And the judge found and held at paragraph 3 of the judgment that the differences between the two patents were immaterial. So even when we look at the 810 patent, I'm going to take that by reference to the description in this version, so that we don't end up marking up two documents. So I hope that whilst this is a little bit repetitive, because we're going to start by looking at the background art, it will assist to reinforce the points that we've already been talking about. And in particular at supplemental bundle page 3, if we start at paragraph 2, we'll see that this helpfully tells you about ARC, and it tells you about the fact that you have ACS and NACS, and that this, I'm looking at the end of the paragraph, this response signal is transmitted to the base station using an uplink control channel such as a push, which is what we're talking about here. Then for the moment we can skip over paragraphs 3 and 4, and go on to paragraph 5, which is telling you about spreading the ACNACs with a Zadov-Chu sequence, first of all. So it says investigations being carried out into code multiplexing a plurality of response signals from a plurality of mobile stations by means of spreading using a ZC sequence and Walsh sequence, as shown in figure 1. And it explains that the ACNAC is subject to first spreading by a ZC sequence with a length of 12. Then there's some stuff about inverse fast Fourier transform that we don't need to worry about. But starting at about line 8, it says then this signal is subjected to the IFFT, is subject to second spreading using a Walsh sequence with a sequence length of 4. And so that's what we've learnt about already. You spread the ACNACs with the Zadov-Chu sequence, then with the Walsh sequence. And then he says, the patentee says at the end, therefore in an ideal communication environment, response signals from a maximum of 48 mobile stations can be code multiplexed. And then if we go on to paragraph 7, where it starts talking about LTE, it introduces the CQI, the channel quality indicator signal, and it explains that that is code multiplexed as well as the ACNAC signals, and that just going down to line 41, a mobile station spreads a CQI signal by a Zadov-Chu sequence with a sequence length of 12 and cyclic shift value P. And then, just jumping over the bit about IFFT processing, it says since the Walsh sequence is not applied to a CQI signal, a Walsh sequence cannot be used in the base station for separation of ACNAC signal and CQI signal. And then it explains how that allows the two different types of signals to be separated. So moving on to paragraph 9, that tells you about the problem of interference between signals as a result of delay spread. And in particular, the last sentence of paragraph 9 is important, and that says that if Zadov-Chu sequences with mutually adjacent cyclic shift values are used, there is a possibility of ACNAC signal separability degrading. So you might need some gaps, essentially. And it goes on to explain that therefore, or heretofore, when performing code multiplexing of plurality of response signals by Zadov-Chu sequence spreading, a cyclic shift value difference, or a cyclic shift interval, i.e. gap, I interpolate there, has been provided between ZC sequences that's sufficient to prevent the occurrence of the interference between Zadov-Chu sequences. And so basically it explains that this problem about signal separability degrading, which has been identified in paragraph 9, has previously been addressed by just using every other Zadov-Chu sequence. So in other words, you just use 0, 2, 4, 6, 8 and 10. So you're leaving a gap between each one. And that means at that point you can only code multiplex 24 mobiles because you've left these gaps. So then we move on to paragraph 11. And paragraph 11 refers to Nokia, and you can see that that's called non-patent document 2, but if you look just above the disclosure of the invention in column 4, non-patent document 2 is in fact Nokia, the Nokia piece of prior art. And it says that in Nokia, you've got first spreading is performed using 6 Adolf-2 sequences with cyclic shift values 0, 2, 4, 6, 8 and 10. So in other words, the every other sequence approach. And then you use the Walsh sequences. And then it goes on to figure 6. And figure 6, which it's probably helpful to turn up, it explains that that uses an arrangement of CCEs that can be allocated to mobile stations for ACNAC signal transmission, you can see from the figure itself that that gives you the sort of checkerboard tablecloth pattern of the ACNAC signals. Now, I'm not going to get into the bit at the bottom of column 3 at the moment, which relates to the putches mapping onto the CCEs, because that's really relevant to the 8-10 patterns. And for the moment, we don't need to understand that. We just need to see that in figure 6, as it explains at the top of column 4, the horizontal axis indicates a Z-of-2 sequence cyclic shift value, and the vertical axis indicates a Walsh sequence number. Since intercode interference is extremely unlikely to occur between Walsh sequences number 0 and 2, as shown in figure 6, Z-of-2 sequences with the same cyclic shift value are used for CCEs subjected to second spreading by Walsh sequences 0 and CCEs subject to second spreading by Walsh sequence 2. So I mean, it's easier to understand from the diagram, quite frankly, than the words. You get the checkerboard pattern. It's with figure 6. And at paragraph 16, which it has the list of figures, you'll see, this is on page 5, you'll see that figure 6, at line 29 to 30, is referred to as conventional case 1. And I'm going to come back to that in a minute, but before and what the judge said about that. But before I do that, I just want to also turn to paragraph 12, so that's back on page 4, column 4. And that relates to figure 7, and it's now under the heading disclosure of the invention. So everything else that we've looked at so far was under the heading background art. We're now under the heading disclosure of the invention, and that talks about figure 7 towards the end of paragraph 12, and it says that such an arrangement of CCs that can be allocated for CQI use, sorry, this is introducing CQIs. Perhaps we need to start at the beginning of the paragraph. So, in the case of LTE, which a CQI signal is code multiplexed as well as an ACNAC signal, therefore it's conceivable for provision to be made so that of the CCEs having the 2 cyclic shift interval mesh structure shown in figure 6, CCEs using ZC sequences with a cyclic shift value of 3 and a cyclic shift value of 4 are employed for CQI use and are not employed for ACNAC use. So we're going to put some CQIs into the resource block now, as well as the ACNACs, and such an arrangement is shown in figure 7. And so if we now look at figure 7, we can see that the difference between figure 7 and figure 6 is that we've introduced some CQIs at columns 3 and 4. So they're shaded, and you can see at the bottom it says for CQI use. This is actually something called a mixed resource block, because it uses CQIs, it has within it CQIs and ACNACs. And the judge found that mixed resource blocks were not part of the CGK, but in fact mixed resource blocks are mentioned in Nokia, so we don't need to worry too much about that for our purposes. But here you'll see again figure 7, if you look at paragraph 16, is another drawing which is referred to as a conventional case. And what the end of paragraph 12 explains is that a problem with the mesh structure shown in figure 7.
Sorry, just before you go
Yeah.
on, and I appreciate where you're going with this to some extent, but a tiny detail which puzzles me about paragraph 16
Yeah.
is that the parentheses both say conventional case 1,
Yes.
but they're different from each other. Are you able to enlighten me as to what the 1 is referring to?
I'm afraid I am not. I mean, we place emphasis on the use of conventional case.
Although the judge has found, certainly with regard to figure 7, which I think is the one that matters more, that it's nowhere to be found in the prior art.
Yes, and I'm going to come to that bit of the judgment now, because we say the important thing. Let's turn it up now before we get to paragraph 13. It's the judgment at paragraph 227 to 228, which is core 5, page 111. So perhaps I can just ask my lords to remind yourselves of the contents of paragraph 227 and 228 of the judgment. And just to put this in context, I mean, what we were trying to do at trial is say, well, because it's in the background art, then that shows it's part of the CGK, and that's the submission that the judge is dealing with here. But what he doesn't deal with, and we say is important...
Well, just before you go
Yeah.
on, as I understand it, you don't challenge the accuracy of what he says in 227.
That's right.
Thank you.
What we say about 227 and 228 is that there is no finding here or indeed anywhere else in the judgment that the skilled person reading the patent would see that figures 6 and 7 were referred to as conventional and appreciate that that was a mistake. So they would just take that at face value in our submission. And obviously we say that matters when it comes to construing the claims. I mean, that's one of the points that we have and make in relation to the description. And I'll obviously come back to that and explain the point in more detail. But the point is that the skilled reader reads this and they're just, they accept what they're told, which is that it's conventional.
Well, this is part of the reason why I asked about the wording conventional case 1, which I can't find being commented on the judgment, whether it may be there somewhere. Because, as I observed earlier, the same language is described to use both figures, but on their face they're obviously different. And you needn't deal with this now, but it seems to me that that might be suggested to indicate straight away to the reader that something is wrong with the document.
Well, my lord, that's not a point that's taken by the other side, and they haven't got a respondent's notice, and they're not saying that that's a point that it is a finding that the judge should have made. I mean, I appreciate that's not the be-all and end.
But he has made a finding when the specification describes figures 6 and 7 as conventional. That's simply factually wrong.
Indeed, indeed. But that isn't the same with
And
respect.
your submission is that that's to be disregarded, is it?
Well, we say that the skilled reader looks at the patent and takes it at face value unless there is an obvious mistake, which is not something that there is any finding that the skilled person would see that this was an obvious mistake.
Well, hang on a minute. The skilled person knows what his or her own common general knowledge is. Reads this, it says it's conventional. Well, it's obviously not conventional because it's not in their common general knowledge, so found by the judge.
But, my lord, there is a difference potentially between conventional and common general knowledge. So it may be that the reader appreciates that this is not part of their common general knowledge, but equally they can still understand from the specification, because they're being told that this is conventional, that this is not the inventive thing about the claim, because this is the conventional thing. And that, we say, is relevant when it comes on, to construing the claim and understanding exactly what the scope of that claim is and what matters in the claim. And we say, I mean, I'm previewing what I'm going to come to, that pushes the skilled person into focusing on the characterising portion, and in particular focusing on the fact that the characterising portion requires use, because they are being told not just by the fact that it's the characterising portion that's the inventive bit, but also by the fact that in the description they have been told that what's in the pre-characterising portion is conventional.
I think I follow how you put that, but what does it mean to say that something's conventional if it isn't common general knowledge? How can it be conventional if it isn't common general knowledge?
Well, it just means it's not the inventive bit. So it could be something not inventive, but not necessarily forming part of the common general knowledge, which has obviously got a specific legal definition, which requires that it be widely known and so on.
Well, I understand that, but taking the case of figure 6, that starts off with a cross-reference to Nokia. And as soon as the skilled person follows up the cross-reference, they find that what's shown in figure 6 isn't Nokia.
Well, except the judge actually found that figure 6 is not Nokia. So
exactly, that's what I was
exactly.
getting to.
So
So if the skilled reader thought that when it said conventional, it meant conventional in the sense that it's disclosed in the prior art referred to, namely Nokia, they would find out straight away that that's not so. So at that point, the skilled person knows, one, that what's in figure 6 is not part of their common general knowledge, so not conventional in that sense, and it's not in the prior art referred to in the specification, and therefore not conventional in that sense, even if that's what conventional means.
Well, it's not conventional in the sense that the patentee can't point to a specific single document that refers to it in the way that they have done with Nokia, but that doesn't mean that it's not something that is known more generally.
Ms. Lane, can I just make sure, following on from my Lord's question, I think the skilled person doesn't even have to turn up Nokia, because the patent says that Nokia uses 6 ZC sequences, and figure 6 uses more than 6 ZC sequences. So you don't even have to read Nokia to see that there's a difference between what the patent says Nokia says and what figure 6 shows. That's right.
Yes, I mean, just to be clear, I'm not saying that figure 6 is part of Nokia.
No, I understand that, but I just want to make sure I haven't misunderstood. It's also true, isn't it? I mean, if I've got it wrong, just tell me.
Yeah.
But I think it's right that figure 6 doesn't show using 6 ZC sequences. It shows using more than 6.
Yes, it does. Yes, it does.
And just for completeness, does the word conventional feature anywhere else in the patent?
Not as far as I can recall, and I think I would recall, but just if I've got it wrong, someone will tell me, but it's just figure 6 and figure 7.
Yes.
And just to be very clear, this is just one point, obviously, that we come to in terms of construction. We we have a number of points, so it's not the only point that we rely on. But we do say that it's important that the judge didn't make a finding that it would be apparent to the skilled person reading the patent that this was not conventional and was something else, or that there was a mistake, effectively. Just going back to paragraph 12, because this is where it introduces, the end of the paragraph is where it introduces the problem to be solved by the invention and the object of the invention. And what it says at the end of paragraph 12 is that a problem with the mesh structure shown in figure 7 is that the cyclic shift interval between CCE3 or CCE15 and CCE9 becomes 1, and intercode interference between ZC sequences increases. So it's probably helpful just to look at figure 7 whilst reading that, because what is being said is that when you've got your CQI there, and therefore you've got CQI using CCE3 and CCE15, so that's column 4 in that figure, then you've got potential for interference between column 4, where your CQI is, and CCE9, which is your ACNAC, and that is potentially problematic, and therefore it says at paragraph 13 that it's an object of the present invention to provide a radio communication apparatus and response signal spreading method that can suppress intercode interference between an ACNAC signal and CQI signal that are code multiplexed, and that this object is solved by the subject matter of the independent claims. So basically, the object of the invention is to suppress that interference, and effectively, when we come on to paragraph 15, that is what the patent says, and so it says the present invention can suppress intercode interference between an ACNAC signal and a CQI signal that are code multiplexed. Then you've got paragraph 16, which explains the figures, which I've already briefly taken my lords to, but I just want to call out some other figures. In particular, figure 8 is a drawing which shows the configuration of the base station, and just before we come on to the detail, it's also worth knowing that figures 10 to 13 are all within the scope of the claims, although figure 13, as explained here, is embodiment 2, and I'm going to turn that up in a minute, and then figure 14 is embodiment 3, and that's outside the scope of the claims. So I want to look at those points in a bit more detail by reference to the description as well. And so first of all, figure 10 is explained...
Sorry, just before you go on,
yeah.
Do I understand that from what you just said, that the effect of the amendments to the claims is that whereas embodiment 3 was previously within scope of the claims, that's no longer the case?
Yeah, I can't actually remember whether it yes, my learned junior thinks it previously was. It certainly isn't now. I just can't remember whether it was before.
I was drawing that inference from the way that figure 14 is described. It says according to embodiment 3 of the present invention. So you would naturally think that the claims as granted covered embodiment 3. Although of course one knows that that's not always.
No, indeed. I mean, just by way of preview of embodiment 14, the problem with embodiment 14, and the reason, well, not the problem, but the reason it doesn't fall within the claims is because it has a cyclic shift interval of 3, so the mesh structure of 3 rather than 2.
Okay.
So, but we've got a bit more work to do just on some of the detail in the figures. First of all, figure 10, which we've already looked at a little bit, but we haven't looked at how it's described in the patterns. And the key part of the description is at paragraph 58, which is on bundle page 8. And this is under the heading Embodiment 1, which I think is a couple of pages back. And what's explained in the first part of that paragraph is that various CCEs are for ACNAC use, and the cyclic shift interval of these CCEs is set to 2, so that at a level at which intercode interference doesn't occur. CCE 8 is for CQI use, so you can see that if you've got figure 10 out as well. And then CCEs 3 and 15 are unusable CCEs, and the reason for making CCE 8 for CQI use and making CCEs 3 and 15 unusable is to maintain the cyclic shift interval between Z(2) sequences at a level of 2 or above, at which intercode interference doesn't occur. And so basically, as it goes on to explain, that allows you to suppress the intercode interference by having a gap after the CQI but before the ACNAC. Now, the next paragraph we need to look at is paragraph 63, which is under the heading Embodiment 2, and which explains that a base station and mobile station, according to Embodiment 2 of the present invention, have the same kind of configurations as a base station and mobile station according to Embodiment 1, and differ only in regard to part of the processing performed by the control channel allocation section. Then it explains that the control channel allocation section 102 is shown in figure 8. And so I think I already mentioned that paragraph 16 explains that figure 8 is a drawing of the base station, and obviously, control channel allocation section 102 is part of the base station. And so what this paragraph is telling the skilled reader is that embodiments 1 and 2 differ only in regard to what is going on at the base station. And that's another point, obviously, that we place reliance on when it comes to construing the claim and what it means.
Is that what that paragraph actually means? The reason I'm asking the question is because the paragraph seems to be saying that the mobile and the base station have the same configuration. So the difference it's talking about could be applying to a difference which is just as much in a mobile as it is in a base station.
Well, I mean, sorry, I'm not sure I understand that point, because it says differ only in regard to part of the processing performed by the control channel allocation section. So the only difference is in the control channel allocation section, and that's in and that is in the base station, and we know that because it's part of figure 8.
Right. And the point I was putting to you, which I doesn't feel as though you've addressed, but maybe you have.
Sorry, I think it's because I didn't understand. So
is that what this is saying is that the configuration of figure 8 is applicable to a mobile station just as much as figure 9. That's what it might be read as saying. And so the difference you're talking about, as I understand it, the differ, when it says differ, what it's talking about is the difference between embodiment 1 and embodiment 2.
Yes.
And what it's saying is that there's a difference in the there's a difference, and it says that in a context in which it's said that base and mobile have the same kind of configuration.
Yes, so as I read it, my lord, it's basically saying in embodiment 1 and embodiment 2, the base station and the mobile stations are the same, save that they differ, only in regard to one thing, and that is the processing performed by the control channel allocation section, which is shown in figure 8. Now, I think what my lord is putting to me is that because of the reference to base station and mobile station at the beginning, that you read into the last clause, which I rely on, that the implication is, well, there's also a difference in the mobile station because there's a difference in the base station.
Well, it's not just 63. Look at what it says in 64, where it says figure 12 is a drawing showing CCUs corresponding to switches used by mobile stations, which are referenced by a control channel allocation section according to this embodiment. So isn't that telling you in terms the difference? It lies in the mobile station as well as in the base station.
I'm not sure that that makes any difference, though, when it comes to our point, which is that the skilled reader understands that what you need to do is change what is going on in the base station. And it's only when the base station is doing that different thing that you are then going to get a mobile which is operating in a different way. And so it is important for the purpose of the claims, we would say, to understand that the base station has to be doing the different thing. It has to actually be using the code multiplexing structure.
Well, that may be correct, but it follows that the mobile station is doing something different as well.
Yes, once the base station has told it to, and that's where the change occurs and the difference occurs.
Okay.
So, just moving on sort of in order of the document itself, we've then got paragraph 67, which relates to figure 13, and this is just a case in which 3 CCEs are for CQI use, and that is basically here where you've got unusable columns before and after the CQI signal. So that was the point that we were talking about earlier on, which is that in one claim of the patent, I think it was claim 8, you have got a white stripe both before and after your blue stripe, effectively. So this is a further embodiment. So I'm really just showing my laws that for completeness rather than making any particular point on it. But then we go on to embodiment 3, which is at the top of column 14, which is, as my lords would appreciate, I've already said, outside the scope of the claims. And that again has similar wording to paragraph 63, which says a base station and mobile station, according to embodiment 3, have the same kind of configurations, etc., and differ only in regard to part of the processing performed by the control channel allocation section at figure 8. So again, we say that that is saying that the only difference is in the base station. And then just again for completeness, paragraph 70 and 71 describe figure 14, and figure 14 is outside the scope of the claims because it has a 3 cyclic shift interval instead of a 2 cyclic shift interval. So it's got the wrong kind of checkerboard and is outside the scope of the patent. So, my lords, unless there are any questions immediately on those parts of the specification, we can close up the supplemental bundle and come back to the core bundle and the construction issue. Obviously, I've introduced quite a lot of things that I'm going to refer back to now in this context. And the first thing we need to look at is the judgment and the meaning of code multiplexer structure in the judgment at bundle page 113, paragraphs 242 to 243, and this is the meaning of code multiplexing structure, and we don't obviously appeal this. The judge accepted our submission that it was an abstract logical structure known to the network. And the point, as my lords will have appreciated, is we say that the code multiplexing structure actually has to be in existence or in use in order to fall within the scope of the claim. And we say that for 4 reasons. The first one is the wording of the claims. And so we need to look at the claims again and just remind ourselves of some important parts of the claim wording, which we say are highly relevant to the construction issue. So first of all, integer 1a, the ACNAC signal and the CQI signal have to be spread and transmitted in accordance with a code multiplexing structure. That is the whole thing, and those code multiplexing...
You seem to have skipped the key words straight away, which is a mobile station adapted to.
My lord, don't worry, I will definitely be coming back to adapted to. I'm trying to put my positive case now, but I absolutely will be addressing adapted to. But yes, okay, it says adapted to, but it's adapted to. But the point I was seeking to draw out is the fact that it's a code multiplexing structure, it's the whole thing, and you have to have ACNAC signals and CQI signals from a plurality of mobile stations. And this is the basic point, and it also comes back when we're talking about the nature of the invention, is that the claim is about the whole pattern. So as I said in my introduction about tablecloths, it's the whole pattern that matters here. That is the thing that we're talking about, and that is clear from integer 1a, albeit I accept that it uses the words adapted to. But the parts of the claim which don't use the words adapted to, as I'm sure you'll have appreciated, are the integers which are in the characterising portion. And so once we come to the characterising portion, although we've obviously the patentee has used the words adapted to in various places in the pre-characterising portion, the words adapted to are not used at all in integers I, j and k. So these integers actually say particular cyclic shifts are used. So they're not adapted to be used, they are used, or they are not used in the case of integer 1k. And Optis says in its skeleton argument, well, that doesn't matter because the patentee has used adapted to 4 times in the pre-characterising portion. So effectively we can just read it across to the characterising portion. And we say, no, that actually makes the point worse, not better for them, because the patentee knew how to say or use adapted to language when it wanted to, and it didn't use it in the characterising portion. It used it repeatedly in the pre-characterising portion, and then not in the characterising portion. And we say that that is important. I mean, again, it's one factor, obviously, and there are other factors that I'll come to. So that's essentially the points about the wording. Then we come to the points about the description, which I've already touched upon to some extent. And one of these is figure 7, and the fact that the skilled reader is told this is conventional. And we say, because there's no finding that that is something the skilled reader would understand is a mistake. What that is doing is reinforcing to the skilled reader that what is in the pre-characterising portion is not the invention. It's not the thing that matters. So all the references to adapted to there don't matter because the skilled reader would understand that the conventional figure 7 is actually what's described in the pre-characterising portion, because it's got spreading of ACNAC signals and CQI signals using the 12 cyclic shifts, and then for the ACNAC signal, the orthogonal sequence. So that is all conventional, and that reinforces then the skilled reader's understanding, which is based on the words as well, that you've got to have actual use, as you have in the characterising portion.
Sorry, Ms. Lane, can I didn't quite, this is one of those questions where you'll go, oh yes, that just shows that the judge hasn't understood anything you've said for the last hour. But figure 7 shows the 2 cyclic shift, doesn't it? But that's not in the pre-characterising portion.
You mean the mesh?
Yes. Well, I mean what I said, 2 cyclic shift.
Yes, the 2 cyclic shift interval.
Yes,
Yes.
That's not in the pre-characterising portion.
No, that's...
So whatever pre-characterising portion, whatever the relationship between those two things, the pre-characterising portion and the figure 7 is, it's not as simple as saying that figure 7 and the pre-characterising portion are the same, because the 2 cyclic shift is in the characterising portion.
Yes, that's correct. But we would say it doesn't detract from the fact that the skilled person is going to understand that you need actual use, which is
well, that may be
on a
but
non-use.
I'm only picking up on you sort of skipped very fast as if it was clear beyond peradventure that the pre-characterising portion and figure 7 were the same thing. And that's what I just reacted to.
Yes, my lord, that's an absolutely fair point. Of course, we've also got the fact that figure 6 is described as conventional, and I appreciate that doesn't have the CQI in it. But the point is that all of this, or the fact that figure 6 and 7 are described as conventional, alert the reader to the fact that the patentee is going to want to distinguish these things which are conventional. And we say, alert the reader to the fact that the use and non-use, which are in integers 1i to 1k, so that's not obviously 1l, which I appreciate mentions the 2 cyclic shift interval, but the use and non-use has to be actual use and non-use rather than adapted to use or adapted not to use.
I don't quite understand that submission. I quite understand that you say the skilled reader would think that the claim isn't intending to cover fig 7.
Yes.
But why is it not sufficient that fig 7 doesn't have the 2 cyclic shift in it, and therefore the claim doesn't cover fig 7 anyway?
Well, my lord, I don't say that each of these points on their own would be good enough to force the construction or to justify the construction that we contend, but I do say that it all feeds in to the question of when the skilled reader is looking at the key integers 1i, j and k, which are about non-use, and that's the thing that the patentee has told us is achieving the object of the invention, which is to suppress the code interference. So they are the things that matter, and we say that they are assisted in their understanding of whether there has to be actual non-use as opposed to being adapted not to use by knowing that figure 7 is something which is conventional.
So what might say 1i have said?
Well, it's characterised in that said first spreading unit in each symbol that forms the ACNAC signal is adapted to use said code multiplexing cyclic shift value
Yes, I see.
rather than use. And likewise with J and K. Because the patentee clearly understood how to use that language and used it in the pre-characterising portion.
I mean, you're obviously going to come back to adapted to, but you might alternatively say, well, this is referring to a particular characteristic of the first spreading unit, which is itself governed by the opening words, which is a mobile station adapted to.
Yes, but then it's quite odd to use the words adapted to in integers 1, B and D, which also refers to the spreading unit. I mean, it's used it 4 times in the pre-characterising portion and not at all in the characterising portion.
And again, taking out of your order, why would they only want to catch use as opposed to adapted to use?
Well, I mean that's another point essentially that we make. It's sort of my 4th point, but just by way of preview, because an adapted to claim is extremely wide, and so it can lead to invalidity. And we say it does lead to invalidity in this case because that's our fallback case on Nokia, which is we say if you adopt an interpretation of this claim which is so wide that everything just has to be adapted to do it, then that would lead to invalidity. And
Yeah,
that's
but you're wrapping up there 2 different points. One is a point about construction and one is about objective consequences. And I appreciate you say that if the claim is construed as the judge has held, the objective consequence is lack of nullability over Nokia.
Yes.
Let's park that point for the moment.
Yes.
Go back to what we're talking about at the moment, which is the point on construction. And I quite understand you say that a principle of construction which is applicable here is that the skilled reader doesn't interpret the claim as reading on to prior art which is acknowledged in the specification.
Yes.
And so forth. So here we've got Nokia being acknowledged in the specification, so you don't interpret the claim as reading on to Nokia.
Yes.
But isn't the problem with that argument is that Nokia on its face is being distinguished because it's 12 and 6. So, and I appreciate you say, well, the claim covers both, or at any rate, it's indifferent at that level. But on its face, the fact that figure 6 is described as conventional doesn't fit with the idea that they're not intending to distinguish Nokia. On the contrary, they plainly are. So that, in other words, the point I'm putting to you is the same one that we've covered before, but looking at it from a slightly different angle, which is that the skilled reader of this document is mystified by the use of the word conventional as it applies to figure 6 and figure 7.
Well, my lord, I've already said there isn't any finding that the skilled reader is mystified, and so we say that they take
Well,
it at
there
face
is a
value.
finder that it's factually wrong,
Yes.
and a finding that none of this is common general knowledge.
Yes, and we.
So why is the court not entitled to say that the skilled reader would interpret the document accordingly?
And effectively delete the reference to conventional.
Because it doesn't make any sense.
Well, my lord, you have my submission as to why that isn't the right approach, but as I say, it is only one of the things that we rely on in any event in support of our construction. So one is the words, which I've already referred to. There is a second aspect of the description, which I was about to come to now, and that's obviously paragraph 63 and 69, which we touched on in my introduction to the specification. And we say that they tell the skilled reader that the only difference between the embodiments is the control channel allocation section of the base station, i.e. what the base station does. And so therefore you need actual use and non-use in order to distinguish from the prior art and from the different embodiments, which is why the characterising portion requires actual use and non-use, because it's only when you've actually got the base station telling you or telling the mobile what to do, i.e. there is actual use, that there is any difference between things that fall within the scope of the claim and things that fall outside the scope of the claim.
I don't understand that, because as you've pointed out, that what the text says is the base station is going to do something with the channel allocation section, and the mobile then has to react accordingly. So why is not what is required is an adaptation in the mobile to be able to react to the base station when told to do so? Why does you need to read in that it must actually do it? Why is not adaptation sufficient?
Well, my lord, all these points are sort of mutually reinforcing, because you know that the claim language doesn't refer to adapted. So you're looking at the claim language and thinking, sorry, when I say doesn't refer in the characterising portion to adapted. And so the question then is, do I read across the word adapted or not? And if you're told in the description that in fact, in order to be within or outside of the scope of the claims, what you have to have is a difference in the base station, then you know from that the base station actually has to be signalling, and therefore there actually has to be use of the code multiplexing structure.
It's a bit funny in the sense that, the invention is the same either way, isn't it? What you've got in the mobile phone is exactly the same.
Well, I was actually going to come on to the invention now, because we also say that's important, because obviously the invention, as we've seen, is about suppressing intercode interference. And if you've just got one mobile phone which is not actually using a code multiplexing structure, it's just, as Optis would have it, adapted to use it, then you don't have the invention at all. You don't have a mixed resource block. You don't suppress the intercode interference. It's just, as I put it in the introduction, the spools of thread sitting there waiting to be used. And so...
I'm sorry, you started that sentence by saying, if you have just one mobile phone. But if you've only got one mobile phone, then it makes no difference whether it's adapted to or actually using, because you've got no interference in the case where there's only one mobile phone. The whole point of the invention is because it allows for the possibility of multiple mobiles.
Right, well, let's change the sentence then, because the point is still a good one, to saying you've got multiple mobile phones, but they're not doing anything. Because they're just adapted, but they're sitting there. And then you are not using the invention. And so we say that the nature of the invention is important, because it is about, and doesn't make any sense unless you have multiple mobile phones in use and being signalled, and taking up their different roles to make the pattern of the code multiplexing structure.
It feels somehow quite a bit wrong. You say you're not using the invention. I invent some new widget. I've got the invention, which is the widget. I may not be using the widget, but it's still been invented. Is it not the same with a mobile phone? You've invented the facility which is in the phone. You may not be using that facility, but you've still invented the facility. And why then should use affect whether the invention exists or not? I mean, why should use come into what is the invention? It's something that can be used.
Well, it's to do with the nature of this invention, which is that it doesn't, and this is why I go back to one mobile phone. It doesn't. One mobile phone doesn't make any use of it because it's all about the plurality of mobile phones and preventing interference between the signals of a plurality of mobile phones. So obviously you can have an invention as we have here where there's a method, and the method is implementing the code multiplexing structure because the base station is signalling the parameters, and that allegation of infringement was abandoned. And so the question is whether you say that this invention is about, at the level of generality of what is described, is it really about the plurality of mobile phones actually doing it, or is it about a single mobile phone that might be able to do it? And we say it's about the plurality because it's about the whole pattern.
I mean, there would be no point in the exercise at all if there could only ever be one mobile phone. You wouldn't need to program mobile phones so they could do this. But
no.
The invention assumes, as common sense suggests, that there might be more than one mobile phone. So you need to program the mobile phone so that they can do it. And it seems a bit odd that what you're patenting is only what you actually do rather than what you would have made it capable of doing.
Well, we say that is no more odd than saying that there is infringement in a situation where there is absolutely no use of the invention in the United Kingdom, and there never will be. And so we say that's the artificiality here.
Ms. Lane, I can understand the way in which I think I've understood. I think I have understood the way you're putting your case on uses. You say
yes.
It's a bit like a claim to a light bulb. You could write a claim that says what I claim is a light bulb with a glass bulb or whatever. But what you say has actually happened, and you say there are good reasons for it, is the claim says a light bulb when switched on.
Yes.
So it's only actually within the claim when it's switched on.
Yes.
Even though a light bulb switched off would be the same light bulb, it just wouldn't be switched on. So it's only in certain circumstances that it's within the claim. I sort of see that with uses. But this claim also contains a feature of not used.
Yes.
And I don't understand at the moment how, if you actually start thinking about it, these, and I think it also applies to the two different uses, because in fact, at any one instant in time, the phone can't be using, in your sense, one I and one J and one K. It can't do those things all at the same time. So it can't be a phone which is both using what is in I and using what is in J and not using what is in K. It can't do that. It can, over time, it could do some of this.
Yes.
If it was adapted to do it. But as an exercise in construction, to say that this is like a light bulb switched on, it can't be, because it can't be all of these three things at the same time. Unless they mean adapted to do these things.
But that's because it's the invention relates to a plurality, something that happens with a plurality of mobile phones. So that's the difference in my submission.
The claim isn't to a plurality of mobile phones, is it? The claim is to a phone.
It talks about a plurality of in the context of the code multiplexing structure.
Well, I understand, but as a matter of language, the claim is a claim to a phone. I mean, if I misunderstood that, please tell me.
No, my lord has not misunderstood that, but I'm trying to make a different point, which is that the light bulb analogy is not a perfect analogy,
Okay.
because in fact, this is a claim which is not to a single light bulb, it's to a load of light bulbs, effectively, in the form of the code multiplexing structure.
Mm-hmm.
And so it is clear that the invention relates to a plurality of mobile phones, even though the claim is only to a single mobile phone.
Right. So how does it work on the basis that the claim is to a single phone? How does the idea that these words should be read that way work as a matter of construction?
Well, because as a matter of construction, it has to be actually doing the thing, because it doesn't say adapted to.
Okay.
I think I've already effectively covered the final point that I wanted to make before turning to the judgment, which is that the wide construction leads to invalidity. And so, as I've already mentioned, the problem with these adapted to claims, and one of the reasons why we say the patentee would not have wanted every integer to say adapted to, is because it leads to a very wide claim. And that's something that that's something that can be taken into account in construction if the relevant prior art is acknowledged in the specification, and that is supported by the Interdigital and Lenovo authority, which is cited by Optis. And we say that the relevant prior art is acknowledged in the specification because Nokia is referred to at paragraph 11. And we say, and obviously I'll have to make this good when I come on to it, that on the judge's construction, Nokia would render the claim invalid, and that is a reason for construing it in the narrower way that Apple proposes.
So you're going to come back to why the wider construction would lead to invalidity?
Yes. Yes. And now I'm going to, I'll probably be traversing ground here again, but I think we do need to look at the judgment now and where we say the judge got it wrong. And so I'm going to start at paragraph 248, which is...
Just before you do, just
yes.
thinking around that for a moment. If it does lead to invalidity, you're fine. You don't need to worry about construction.
Well...
If it doesn't lead to invalidity, then why does the potential invalidity affect construction?
Well, we say that it is a principle of that one can take into account that if it leads to invalidity, that does affect the construction in certain circumstances where the prior art is acknowledged and so on. And in this case, it would actually make a practical difference because it would, if our construction was correct, then we will not infringe either the 549 patent or the 810 patent. But if in fact it's invalid over Nokia, the only invalidity, the invalidity over Nokia relates to the 549 patent, whereas for the 810 patent, we have to jump another hurdle because that's got an additional integer to do with CCEs that we'll come to in the second part of the submission. So it does make a practical difference in this case which way the invalidity sort of helps us, whether it's by making the 549 patent invalid or whether it's by feeding into construction.
Yes, I see.
So coming to paragraph 248, which is in the judgment in the judgment, page 114. And here the judge is dealing with the final point. It wasn't the final point. I think it was the third point that I made about the nature of the invention. And we say that the judge has made a mistake here about the level of generality of the invention because he says effectively that our submission is looking at too high a level of generality. And we say, no, that's not right, because you find out what the level of generality of the invention and the claims is by looking at the description. And the description at paragraphs 13 and 15, which we've already looked at, tells us that the invention is at the level of generality of suppressing intercode interference. And suppressing intercode interference is the whole point of the code multiplexing structure of the claims. And obviously that level of generality, if you're looking at whether there's intercode interference or not, requires there to be a mixed resource block, and it requires the code multiplexing structure to actually be in existence, which is what we say is required by the claims. Otherwise, we say if it's not in existence, it's not taking the benefit of the invention, and that's a reason for construing it in the way that we construe it. And we also say that we're not actually suggesting an unusually restricted approach to adapted, because you can give adapted its standard meaning in the pre-characterising portion and still say, but the characterising portion does not refer to adapted to, and so that therefore means that the code multiplexing structure actually has to be in use. So we then come to paragraph 249, which is essentially the judge is dealing with the point about paragraphs 63 and 69, which is the point that we've already talked about, that the difference is in the base station between embodiments within and outside the invention. And he says that it's another way of deploying that problem, which we also relied on at trial in the context of clarity. And we say, well, what we're doing is what is required by a proper approach to construction, which is looking at the description and taking that into account when construing the claims. And he cross-refers here to his section on clarity, and I think we should turn that up. And that's at paragraph 435, which is on page 146. And his answer to the clarity point is to say, well, I think it's self-evident that the mobile will have to be able to process different commands from the network. And that's essentially his finding. But he refuses to find that the paragraph is wrong or unclear. And so we say, well, the upshot of that is that the skilled person takes paragraph 63 and 69 at face value, and they say that the difference is in the base station. And I have already explained why we say that's relevant. And we say that the judge, again in this paragraph, and this is a repeated theme, goes back to the point that adapted to means merely suitable. And we, as I think I've already made clear, take it on the chin and say, yes, that's what it means in the pre-characterising portion, but not in the characterised. Those words are not in the characterising portion. Then we come to paragraph 250, which obviously, again, is just the point about adapted to, and I've already discussed that. And then we come to 251, where the judge deals with the wording of the claim and says that our point about the wording is just a lawyer's point. And we say that's not right, because we have also got the points in the description that we've already referred to, which support our construction. And at the end of the day, obviously, you are concerned with the meaning of the language used. And in that context, the fact that adapted to is not carried through the claim, it is an important distinction. And finally, the judge deals with the point on invalidity and says that it's not relevant because the potential invalidity is not at all apparent from the patents, and therefore not a reasonable or even possible guide to the interpretation of the claims. And we say, well, the patent does refer to Nokia, and it's obvious that an approach to the claims which gives them a very wide meaning is potentially problematic from the point of view of Nokia, and therefore it is something that can be taken into account in construing the claims.
Roslyn, I understand that you say that the judge is wrong in the sense that he reached the wrong conclusion on this point and could have taken it into account. But I'd suggest the judge is right, at least to this extent, that if it was the case that it wasn't apparent that the construction would lead to invalidity over Nokia, even if it did, that would be a legitimate point to take into account as a matter of construction. What I'm trying to say to you is, to run this sort of argument as relevant to construction, it's not enough to establish that in fact on a particular construction, it would be invalid over cited art. You also have to show that the skilled reader would in some sense appreciate that, which may not be the same thing. That's right, isn't it?
But it depends in my submission on what is meant by the skilled reader would in some sense have to appreciate that. Yeah. Because what we say is...
But you say they would. I understand you say they would. I get that.
Yes, but they would in the wider sense that the prior art is acknowledged. It's clear that the patentee wants to distinguish it, and it's also clear that adapted to gives the claim a very wide meaning. And so we say that's sufficient.
Okay.
In order to bring this principle into play in this case.
I don't quite get that, because this principle is normally applicable in circumstances where you've got a particular integer of the claim, often a particular word, that is capable of being interpreted broadly or narrowly. And if you interpret it broadly, then the claim reads on to the acknowledged prior art. Whereas if you interpret it narrowly, it doesn't. And that would suggest to the skilled reader that the broad interpretation can't have been intended, and then what was intended was the narrow. But here the argument doesn't work like that, because this is not an argument about the breadth of the expression adapted to. Your argument is a quite different one. You say the way the claim is constructed is that adapted to is in the pre-characterizing portion, it's not in the characterizing portion, and the argument is all about the consequences of the way of the architecture of the claim. It's not about potentially broad or narrow interpretations of any particular word.
Well, it's about broad or narrow interpretation of the claim.
As a whole.
As a whole, yes.
Due to its architecture.
Yes.
Not about any particular word or phrase being broadly or narrowly understood.
I accept that it's not about a specific word or phrase. I mean, it is about the fact that in particular in the characterising portion, the word adapted to is not used in the context of use and non-use. So I think my position isn't quite as stark as my lord puts it, but equally I'm not saying there's a specific word in the claim, and the point is that the skilled person knows that Nokia is being cited, and we say that in combination with all the other things that I've referred to is something that pushes the skilled person to construe the claim overall more narrowly and not read in the words adapted to in the characterising portion, which is what Optis contend for.
Can I just ask to be clear? Suppose you were wrong about your anticipation over Nokia point.
Yes.
Does that mean this point goes entirely?
Well, my lord, I think we would say it doesn't go entirely because the specification still refers to Nokia and the conventional cases in figures 6 and 7. And so those are reasons why the skilled person would want to read the claim more narrowly rather than more broadly.
I suspect you have answered the point. So in terms of the risk of invalidity, even if you were wrong about whether in fact there was a risk of invalidity because of anticipation over Nokia, the skilled person might worry about the risk.
Yes.
Because of the reference
yes.
to conventional and so on.
Yes.
Yes, I see.
My lords, I'm proposing to move now to the adapted to issue because my lords will appreciate that we have to address construction first before we can get to the question of whether in fact in this case the mobiles are adapted to. And so my lords will appreciate that I've now put forward what Apple's construction is of the claim, but when I move to adapted to, we're to assume that the judge's construction is correct. And so in order to understand this issue, we need to know a bit more about the facts in this case. and I can take those to start with from the judgment at paragraph 271, and that's on page 117. And if I could just ask my lords to remind yourselves of the contents of paragraph 271 to 277, and then I will make some comments and submissions on that.
Yeah. Yes.
So my lords will appreciate that we're now talking about what happens in LTE, and that in the LTE standard you've got these various code multiplexing structures set out, and in particular if one looks at paragraph 275 on the top right hand side you've got a code multiplexing structure that falls within the scope of the claims, and paragraph 276 explains that the way in which that would occur, and of course it never does occur in the United Kingdom, but the way in which it would occur is if the base station signalled two parameters. One is NCS1 equal to 4, because that gives you a mixed resource block, and the other is delta put shift equal to 2, because that gives you your two cyclic shift mesh. And just in case it matters, that there are some errors at the end of this paragraph, because I think other parameters that I need not go into should actually say cyclic shifts 4 to 11 and 5 to 10, but nothing turns on that. And just so that my lords can see more clearly or in more detail what is happening, if you turn to tab 20 of this bundle, you'll find a document called Technical Background for Essentiality. And at page 335, paragraph 53, so this was an agreed document at trial, you'll see a parameter NCS1 determines whether such a mixed format resource block is present and the number of cyclic shifts that are available. And then it says this parameter is broadcast by the network and can be configured with values between 0 and 7. And so you've got to have a broadcast by the network of a non-zero value of NCS1 in order to have a mixed resource block. And in addition to that, if your lordships turn to page 338, you'll see at paragraph 70 and 71, there's a reference to delta put shift. And at 71 it says delta put shift may take a value of 1, 2 or 3 and is signalled by RRC messaging. So you've got to have a signal from the base station that delta pod shift is 2, takes a value of 2, in order to be, or have a code multiplexing structure of the claim. So that's the factual background. I want to turn now to the key authority on the issue of what amounts to adapted to, which my Lord Justice Arnold will be familiar with, very familiar with, and it's a tab 4 of the authorities bundle. It's IP from Vodafone. And there are a lot of issues in this case, so it's probably helpful to have a brief look at the head notes so I can call out the key points from that. It was, as we'll see from H2 on page 185, it was an expedited technical trial, and it concerned a SEP, a standards essential patent, and then the name of the patent was given. Vodafone were alleged to have infringed the patent in the operation of their 4G LTE telecommunications network. Vodafone denied infringement, relying inter alia on arguments on construction on the defence of Crown use of Damon means principle, and as well as, and this is the important bit, counterclaiming for declarations of non-infringement. And then there was a challenge to validity and essentiality, and further down at Roman 4, essentiality is referred to again as being one of the matters in issue, and Vodafone's non-infringement arguments at Roman 5. And then turning on in the head note to page JA192 of the bundle, in the findings at H25, that's subparagraph 11. IPCOM's argument that the judge had erred in his finding that the base stations were not set up to send because they were not appropriately programmed or adapted or configured to send the barring parameters was rejected. The setting of the base stations would have to have been changed by the operator to make them operate in a different way. And this was true whether the settings were changed using Vodafone's network management software, a different tool, or manually. It was true that they were capable of altering their mode of operation so as to send the relevant signals as soon as their settings were changed, but without that change, the base stations could not operate in Annex C mode. So just to be aware that if my Lords now turn to paragraph 46, which sets out the claim that matters for this purpose, which is claim 7, that there are just two differences which don't actually matter, but for ease of understanding. One is that this is a claim relating to a base station, so we can see it says a telecommunication system having a telecommunication network and at least one base station. So it's actually a claim to a base station. We're obviously here talking about a claim to a mobile, but it doesn't matter, the same considerations apply. And the wording here was set up to send, so it wasn't adapted to. However, if we now go on to paragraph 71, which is at page 212, it says claim 7 requires that at least one base station is set up to send, etc. So the judge recorded at 89 that Vodafone contended that set up to send meant that either there was appropriate programming in the base station to send the relevant signals, or that the base station was adapted or configured for such purpose, and IPCOM accepted this. So basically, although the wording was set up to send, it was agreed that it was effectively adapted to wording. So then we get to the key part of the judgment, which is starting at paragraph 104. And I'm going to split this up into chunks. So starting off with the facts, which are really from 104 to 109. Could I ask my lords to remind yourselves of those paragraphs, and then I'll make some points about them.
Yes.
So basically, the issue is of infringement of a product claim, Claim 7, that's what it says at 105. So just like in this case, and there's no claim for means essential. And then paragraph 106, IPCOM accepts that set up to send means either that there is appropriate programming or that the base station is adapted or configured for that purpose. And the issue is whether the base stations satisfy this criterion. Are they adapted or configured for that purpose? And the focus is on what happens when the base stations are instructed to respond to an emergency request, and then set out at paragraph 107 is the evidence of the Vodafone witness, which explains what happens. And we say that the critical paragraph is paragraph 5, because effectively what you've got is essentially a load of introductory stuff, if I can put it like that, in the first 4 steps. In the same way you could have introductory stuff in our case, but the critical point is at paragraph 5, which is that based on the configuration changes caused by Lima, each relevant OSS, which is the operation support system, sends commands using configuration changes in each relevant base station. Once the configuration changes are achieved, the relevant base stations commence transmitting the parameters necessary to implement MTPAS. And so that is what has to happen in this case, that the OSS sends these commands causing configuration changes. And then 109 talks about the way in which the judge describes steps 2 to 5 in confidential Annex 2. And I don't think I need to particularly draw anything out of that. So that's dealing with facts. And then the judgment goes on to look at the law, and in particular to look at Philips and Nintendo. And could I ask my lords to just read paragraph 110 and go on to 112, please?
Yes. Yes.
And so basically this is outlining the facts and the findings in Philips and Nintendo, and pointing out, IPCOM pointed out that this reasoning shows that a computer may be appropriately programmed to satisfy a claim to means suitable for carrying out a function if the relevant software is present in the apparatus, even though the software has not yet been loaded into memory, because the apparatus has not yet been switched on. So that's a case where the question is, or the activity that has to be carried out is simply switching the machine on. And then we go back to the facts of IPCOM and Vodafone, and in particular the judge's finding. And at paragraph 225, which is set out at 113, he says that this is the first instance judge, changing a base station from one which does not operate an infringing method into one which does is not as simple as choosing whether or not to supply power to it. And in particular at the end, he says the fact evidence establishes established that making the change was not a simple matter of supplying power. On the contrary, Vodafone's evidence shows that the change requires reprogramming the base station. And again in paragraph 226, he says IPCOM submitted that the reprogramming was akin to flicking a switch, and he disagrees with that. And he says at the end of that paragraph, but the fact remains that until the additional programming is done, the base station does not send the barring parameters, nor is it adapted or configured to send them. On the contrary, it is adapted and configured not to send the barring parameters. So the basis of his decision...
Sorry, I've lost you. Where are those words?
Sorry, that is right at the end of 226, nor is it adapted to...
I see, yes.
Yeah. So the point to draw out of this is that the first instance judge is saying that what is required is reprogramming. And he then goes on at 114. We've got another reference to the judgment of the first instance judge, which is relating to essentiality, and there it's said that the judge approached the system holistically. And he then sets out, at the end of that paragraph, this is the first instance judge, conversely, if the LTE network requires some form of adaptation, configuration, or additional programming going beyond the mere supply of power, then it is not set up to send, and acts done in relation to it will not infringe on conditional claim 13. So I think you need to understand, or in my submission, you need to understand two things about the first instance judgment. One is this factual point that the judge was talking about reprogramming, and that becomes an issue on the appeal. So he talks about reprogramming, but the test he's applying is adaptation, configuration, or additional programming. And so when we go on to paragraph 115, my Lord Justice Arnold says, rather the crux of the judge's reasoning was that the base stations were not set up to send access information because that required reprogramming the base station software. IPCOM disputes this. So IPCOM said it wasn't reprogramming. And then Vodafone said, oh, you can't take that point, we're on appeal, it's a point of fact. And there's then discussion about whether this point, which is said to be a challenge to the facts, can be taken on appeal. And at paragraph 116, the judgment refers to Annex 2 referring to changing the settings of the base stations and not mentioning reprogramming, whereas the body of the judgment refers to reprogramming the base stations rather than changing their settings. So there seems to be this inconsistency in the judgment at first instance, that the annex referred to changing the settings and the body of the judgment referred to reprogramming. And at paragraph 117, the judgment says, in my judgment, the language which the judge used in Annex 2 is more accurate, as can be seen from Vodafone's own summary, quoted at paragraph 107 above. So this is important. My Lord Justice Arnold is finding here, well, no doubt my Lord Justice Arnold will tell us what he was finding here, but in my submission, it is that Annex 2 is more accurate, i.e. changing the settings, and the reason that it's found that that's more accurate is that Vodafone's own summary, which is the one that we looked at 107, talks at point 5 about sending commands causing configuration changes, i.e. changes to the settings. This does not talk about reprogramming. But, so that's the point. There's this appeal on the facts, first of all, and effectively the judge at first instance is found to have wrongly used the word reprogramming in the body of the judgment. But then it says, even so, I do not accept IPCOM's argument that changing the settings of the base stations is equivalent to the scenario considered by Burstjay, in Philips and Nintendo. In that case, all that had to be done was for the apparatus to be switched on, at which point the software would be loaded into memory and would start running. In the present case, the settings of the base stations had to be changed by the operator in order to make the base stations operate in a different way. So what's being said here is it doesn't matter that the judge said reprogramming. Actually, we know it's changing the settings, and changing the settings is not equivalent to simply switching on and off. And it goes on to say, and this is another important passage, that it's true that the base stations were capable of altering their mode of operation so as to send the relevant signals as soon as their settings were changed. But without that change, the base stations could not operate in Annex C mode. So something has to be done. The settings have to be changed before the infringing mode is in operation. And then again, rejecting counsel for IPCOM submission that this is analogous to a radio, which has a switch to change from mono to stereo. And then going on to say, the judge was therefore correct to conclude that in normal use, the base stations were not appropriately programmed, adapted or configured to send the barring parameters. So the Court of Appeal repeating there the ratio of the judgment at first instance, which is the question is whether the particular apparatus was programmed or adapted or configured to send the barring parameters. And so we say that...
Before you go on,
oh yes.
can I have your submission? Do you dispute that this is a question of fact? Now, as you pointed out, in that case, the Court of Appeal felt able to review the judge's finding of fact for the reasons stated, albeit it came to the same conclusion. But nevertheless, it is it not, a question of fact?
Yes, but, and this is the critical point, and I'll just sort of preview this because I think we're nearly at 1 o'clock, something to think about over the short adjournment, that the problem here is that the judge hasn't applied the correct test, because when we look at the judgment at paragraphs 280 onwards, I will come back to this in more detail. In every single, so 280 is the start of this, but
It's strange to say that he hasn't applied the correct test when he's set out a large chunk of the relevant passage from IPCOM, including in particular the decisive paragraphs.
Well, two things on that. First of all, he hasn't set out all the decisive paragraph because he hasn't set out paragraph 107. And in my submission, he hasn't understood the dispute of fact. And he has, more importantly perhaps, in paragraphs 284, 285, 287, 288 and 289, he only refers to reprogramming. So he doesn't refer to programming, adapting or configuring. He just refers to reprogramming, which means that when he asks the question at paragraph 287, I agree that if reprogramming the Apple phones were required to achieve the result, then they would not be so adapted. But it is not required. He is not asking the correct question, which is reprogramming or adapting or reconfiguring the phones required? And we say, yes, a configuration is required because it is not just switching on and off, it is signalling the particular parameters that we looked at in the judgment and also in the technical statement on essentiality. So he hasn't considered the correct facts because he's applied the wrong test. So we say that's just a plain error of law, and it's not a question of reconsidering a decision on the facts.
And that probably is a
Yes,
convenient
yes.
moment.
I'm going to do more on this after lunch if my lords can bear it.